Recording now.
Beautiful.
Okay, and then Trent, do you mind just making me a co-host so I can, thank you. Okay, perfect. Let's see. All right. Can everyone see that okay? I'm gonna put it on presenter mode, but. Right.
Yes.
Perfect, thank you. Okay. All right, do we just see the presentation and not the presenter's view? Or is it?
I can, why don't you go full screen, Alex? I can see,
Okay. You can see the notes, eh?
yeah,
Okay. Okay.
there you go. That's better.
Okay, I'll just use this, that's fine. Okay.
Thanks for your patience, folks. Appreciate it.
All right. Okay, everyone. Thank you so much for joining. My name's Alex, and I'm a CLS student at Western Law. I'm in my last year, and so we're going to be talking tonight about removal of a child from your care. To get started, I'm just going to start by reading a land acknowledgement. So I acknowledge that Western University is located on the traditional lands of the Anishinaabe, Haudenosaunee, Lenape, and Attawandaron peoples on lands connected with the London Township and Sombra treaties of 1796 and the Dish with One Spoon Covenant Wampum. This land continues to be the home to diverse Indigenous peoples, whom we recognize as contemporary stewards of the land and vital contributors of our society. Okay. So just to kind of get started, as a general disclaimer for everyone, I am a law student, and so I am unable to provide any legal advice whatsoever. And further to that, answer very specific questions as they pertain to you or your family or someone you know. This presentation is for general legal information, and it's not legal advice. The last slide of the PowerPoint will have resources, which will direct you to very great people who can answer specific questions for you. Okay, so. Okay, all right, so to get started, I just wanted to quickly talk about the main piece of legislation that we have here in Ontario. So the Child, Youth and Family Services Act, or the CYFSA, is the Ontario piece of legislation that governs over all child protection and everything related to child protection. It prioritizes the best interests of the child, and it focuses on protective measures that are the least disruptive to the child involved. Okay, so in Ontario, we have child protection agencies, also known as the Children's Aid Societies or Child and Family Services. Tonight, I'll just be referring to them sort of as a grouping and as the CAS, and that's kind of commonly is how they're referred to. These organizations investigate allegations of abuse. They work with families to help keep families together, and if necessary, they will remove children. They are organizations who will additionally assist with foster care and adoptions as things kind of progress. So there are very specific rules and procedures that the Children's Aid Societies have to follow, and a lot of those are listed in the CYFSA and the things that they need to prioritize when they first become involved with a family. But essentially, their primary goal is to ensure that children have access to basic necessities like food, shelter, and to prevent them from being in any kind of risk of harm or danger. Okay, so when a child is removed from a parent's care, it's because they've been determined to be in need of protection. And this comes directly from the CYFSA, and it's often the phrase that's used. So in other words, the CAS believes that there is serious or immediate risk of harm to the child. Now there's specific, so in Ontario, if you are under the age of 18, you are considered a child, but there are specific conditions for children who are 16 and 17. So in order for them to be removed from the home, they have to consent to that removal. If a child is under the age of 16, their consent is not required for the removal. So what does to be a child in need of protection mean? This phrase comes again directly from the legislation, and essentially it can include things such as a child that's left uncared for or neglected. So they're lacking access to food, shelter, sleep, clothing, things like that. They are being abused or they are likely to be abused, and abuse can include physical, emotional, or sexual. And again, this further includes if you aren't conducting the abuse yourself, but you're aware of it and you're not taking adequate steps to stop it from happening, the CAS will likely get involved with the family. And additionally, the last thing that kind of falls under this umbrella of in need of protection is when a child is exposed to violence in the home. So that can be anything from intimate partner violence to, violence between another parent and another child, or another family member living in the home and another party. It's family violence is sort of an umbrella. So anything like that. So how does the CAS get involved with the family? So any person can make a report to the CAS if they're concerned about the child's safety, but there are specific people who have a responsibility or a duty to report. And these include doctors, teachers, social workers, religious leaders, daycare workers, amongst others. And essentially, if they don't report any concerns that they have about the child to the CAS, they could be charged with a crime. And further to that, the duty to report is ongoing. So if they made a report to the CAS last year, but a child shows up and there are new concerns, they have a duty to report once again. So that duty is something that is ongoing and continuous. So removal of the child. So the CAS can decide to remove a child from your home if they've determined to, again, if the child is in need of protection, and the removal from the home is the only way that the CAS feels they can keep the child safe. The CAS has the ability to enter your home by force and or with the assistance of the police. In some cases, they will obtain what's called a warrant, or it's a legal document approved by the court that allows the CAS, gives them authority to enter your home and remove the child. But it's not in every case that you'll be presented with a warrant, and they do have the authority to remove the child. So it's also important to note that a removal is not always the first step that the Children's Aid Society is going to take. So if someone or you've been contacted by the Children's Aid Society to have an interview or just a phone call, it's really important that you speak to legal representation and understand what's going on and figure out what the next steps are to figure out what's going on. Again, this doesn't automatically mean if the CAS reaches out to you or someone you know for that conversation, it doesn't mean that automatically your child is going to be removed. Again, that's why it's so important to have access to legal advice. And that brings me to probably the most important point that I'm going to make tonight, and it will be repeated time and time again to really express how important it is. But if a child is removed from your home, it is extremely important to speak to a lawyer as soon as possible, obtain legal advice. And like I said on the last slide, I'll provide you with some resources that could be helpful and could point you in the right direction. Okay, so during the removal, some things to keep in mind. You're going to want to focus on the child and keeping them calm. Likely they are going to be removed and they won't be home for a few days. And so it's really important to focus on what can you help grab for them that they might want or they might need. Medications, things like that, clothes, toothbrush, stuff like that. You can ask the CAS worker who attends for their ID from the CAS and their contact details. So business card, something like that. It's important to note as well that the CAS workers will always be taking notes, whether that's during a removal, during a conversation, and that those notes can be used in a court proceeding. So it's really important just to be focused on the child in those moments and to be focused on what they need. On this point, I just want to express it is helpful to have a good relationship with the CAS worker who will be assigned to the family, that to your family, to you, and that you will commonly be interacting with and working with. That way, you just have better access to very clear expectations on what's expected of you throughout the process. It's someone for you to get in contact with if you have questions or concerns. That being said, while it's really important to have a good relationship with the CAS worker, the CAS won't assist you with any kind of legal proceeding. And again, it's extremely important to have independent legal advice. And if you do develop a good, strong relationship with the CAS worker or someone you know does, just know that you can always talk to legal counsel about how to respond to their messages, how to play out that relationship, and how to make sure you're doing what's best for your family and your child. Additionally, during the removal, if the police are in attendance, you can also ask for their names and their badge numbers. When a child is removed from your care, they're going to be taken to a place of safety. So this can be foster care or hospital. Potentially, if you've worked with the CAS in the past, you might have a family member or somebody on record, and the child could be taken there. So you can always request with the CAS that a child be placed with a family member or someone in your community, but the CAS has to conduct a formal assessment of both that individual and their home, and that takes time. So again, you can always make these asks, and it's important to know that you can make them, but ultimately it's going to be most important to obtain legal advice and figure out what exactly the next steps are going to be. Additionally, you can ask the CAS during a removal where they're going to be taking the child, but they don't have to tell you, and they're under no obligation whatsoever to tell you or give you that information. Okay, so after the removal, again, it's up there. The first most important thing is to call a lawyer, get some legal independent advice. And you can also take notes of what's happening. So some things to include would be the date, the names of the people who were in attendance. So if you didn't happen to get a business card, but you grabbed the CAS worker's name, write it down. How your child was acting, who else was present, if there was anything said during the interaction, write that down as well. It can all be helpful. As I'm, this is something that is extremely traumatic, not just for the child, but for the parents involved when it happens. And so the sooner you can write down the details of what happened, the better it's going to be, because it's going to be something that's difficult to quickly be able to recall. And so it's helpful to have those notes. Now, the 5 days after a child is removed from the home, those are the most important days. They're extremely, extremely important. And part of the reason why it's so important to obtain legal advice and speak to a lawyer is because as soon as the removal happens, the CAS has 5 days to bring a court proceeding. So one of 5 things can happen within those 5 days. Number one, your child could be returned home. Now, this is only going to happen if the concerns that the Children's Aid Society have are no longer present. Number two, if you've got, so this is specific for people who have a family order. So if you've got a court order that says someone has decision making, the other person has parenting time, potentially the CAS will use that order to figure out where to place the child, but that's only specific for people with court orders. The third thing is that the CAS can ask you to sign what's called a temporary care order. So essentially, this agreement is going to say 2 things. The first thing is that currently you are not able to care for your child. And number 2, you agree that placing the child with the CAS, you agree to having that happen for the temporary period. So again, it's really important to speak to a lawyer for this reason. So that, in addition to what's called consent forms, the CAS can be asking you to sign. A consent form essentially lets the CAS have access to information from teachers, doctors, any other adults in the child's life that you need to sign an authorization for. So both of these things, the CAS can ask you to sign at any point, not just after the removal. And it's important to know that you don't have to sign that right away. You have to, respond to them within a reasonable period of time, but you have the right to say, I would like to speak to a lawyer. I would like to get some legal advice about this, and I'll get back to you. You have the right to pause and seek out that information for yourself. So the fourth thing that the CAS can do is that they can start a child protection court application. So this basically starts a court proceeding. The first appearance will happen within the 5 days. And again, that's why it's so important to speak to a lawyer and obtain that legal advice, because likely if you show up without a lawyer or without legal advice on what to say or how to proceed, the court will make an initial temporary order and then set a new court date for a couple of months, a month, however long, but it means more time away from your child. And so it's really, really important that if this is what's going to happen, if this is the next step, and you are properly equipped to handle that next step. Duty counsel will be present at pretty much, the majority of court dates, but they're limited in what they can assist with and how they can assist you. And so it's really, really important, again, just to have a conversation, get on the phone, make some calls, and obtain some legal advice, especially in advance of this court date. And then the last one is specific for First Nations, Inuit, and Métis children. So if your child is First Nations, Inuit, or Métis, it's important to let the CAS worker know, because there are specific considerations, cultural considerations, that need to be considered by the CAS. So for example, the CAS has to give information to you about resources that are specific to your child and your child's band or community. The CAS has an obligation to inform your child's community or band of what's going on and to keep them informed about what's going on. So it's really, really important that if you are First Nations, Inuit, and Métis, and your child also identifies, that you let the CAS know. Okay. Now, let's see here. You can also ask to have time with your child after the removal happens. But again, the CAS doesn't have to consent to this. And that's further reason why you should get in contact with a lawyer, because they can assist you in having that conversation and figuring out what that's going to look like in terms of timing and how often. So that's just something to know as well. You can request it, but it sometimes makes it easier speaking to a lawyer and figuring out what those next steps are going to look like. Okay. Oops. Okay. All right. So if you and the Children's Aid Society, it's just a little bit of an overview. Again, I just really want to reiterate that after those 5 days, if you haven't spoken to a lawyer, it's really important you think about doing so. But eventually, after those 5 days, if you and the Children's Aid Society cannot reach an agreement about where the child should be placed, you're entitled to a hearing or trial, as it's commonly known. And there are essentially 5 outcomes. This is simplifying things. Again, more reason to speak to a lawyer, because they can give you specifics on what will happen based on your specific circumstances. But there are essentially 5 possible outcomes after a child protection trial. So the first one is a dismissal. The court essentially decides that there are no child protection concerns and there are no child protection orders needed. The second one is a supervision order. So the child will remain at home, but the Children's Aid Society will remain involved with the family. And there's going to be certain terms and conditions that go along with that. And again, it will be very specific to you, to your family, and to the child's needs. The third is an interim society care order. So essentially the child will be ordered to a time-limited custody of the Children's Aid Society. So that could be a foster parent, that could be placed with another person, that could be using a customary care order, things like that. And then the fourth option is an extended society care. So the child is permanently placed in the custody of the Children's Aid Society, and potentially this could lead to adoption further down the road. And then a custody order. So this would be a parent or a relative or a community member is given custody of the child. So they've transferred custody over to somebody else in the child's life. Okay, and as I said, this is the list of resources that are fantastic. Legal Aid Ontario is always available. The Family Law Information Center, that's the number for the London. Their office is in the courthouse and they are fantastic. And if they can't directly help you, they can absolutely point you in the right direction of another organization who can. I've also included AFLOSA, which is a great organization for First Nations, Inuit, and Métis families. I don't believe that they directly do child protection work, but they do a lot of the support work that's necessary for this type of process. And they can also point First Nations, Inuit, and Métis families in the direction of people who can better assist. And then I've also just made a note here about unbundled services or limited scope retainers. So these will be lawyers. All you'll need to do is essentially just a very basic Google search of child protection lawyers in your area and giving them a phone call and seeing if they'll take on this type of client. Essentially what this means is you're not paying for a full lawyer, you're not paying for the full service. They will just assist you with certain things where they can help you fill out certain forms, they can give you certain pieces of advice, but you're not taking on the financial side of things that often comes with family court and child protection matters. And then lastly, I've just included steps to justice. Again, the easiest way to navigate that, type in your question and then type in steps to justice into Google. Likely you will have an answer to your question. It's an absolutely fantastic website that gives you up-to-date guides and step-by-step guides on what to do and next steps and that sort of thing. So it is fantastic. And that is the end. I want to stop sharing my screen. And if anyone has, actually, I'll leave it up in case people want to write anything down, but if anyone has any questions, just feel free to unmute and ask away.
Yeah, hi, my name's Terry Fletcher. I have a question. And my question is, under what law does CAS have the authority over and above a police warrant to enter into your home? Because right now, I mean, we're allowed to, anyone is allowed to say to a police officer, no, you can't enter my home unless you have a warrant. So how is it, under what law does CAS have that authority?
So under the Child, Youth, and Family Services Act, the CAS is afforded that authority because the priority of that piece of legislation and of the organization, essentially, it's a branch of the government, right? The CAS. So it's similar to like the police. It's a branch of the government. And they have the authority under the legislation and under the principles of the legislation to advocate for the best interest of the child, that they have the authority to enter if they need to, and if they feel there's an immediate need to remove the child.
Do you feel that that's an antiquated policy? And how do we go about changing that? Because I disagree with it based on the Millennium Indigenous 60 Scoop and Millennium Scoop. And over a representation of Indigenous children in care due to discrimination and racism.
Yeah, that is a fantastic question. And I definitely have my personal opinions on it, for sure. But it's something that, again, if it happens, you need to talk to a lawyer right away for a lot of the reasons that you are alluding to, of just how difficult it is and how horrible it is for all parties involved. Absolutely.
Thank you.
Sorry, Alex, I'm just gonna add something here. I just wanted, so my name is Greg Perrick. I am a review counsel at the Community Legal Services, and Alex is one of my students, and she's one of our best and brightest, if you ask me. And she did a great job tonight, and I thank her for that. One, I just want to point out that in the chat, so we're partnered with, for these presentations, we're partnered with the Rights and Responsibilities Awareness Institute. And Heatham Karki is on the line. You can see his name there. And he had provided a survey, a feedback form in the chat if you want to use that. I also wanted to add, Ms. Fletcher, great question. And I hear you there 100%. And And Alex is right. I talked to a lawyer right away. I would also say one of the unique parts about child protection law is CAS is an arm of the state, and the parents that they deal with have little to no resources very often. That is just the reality of child protection law. And so there's a imbalance of power right away. And the best way to, really, I think, gain some of that power back is by, contacting a lawyer right away who does that kind of law, because they know how to push back when we need to, especially in that short time frame. Within 5 days they have to bring it to court. And what I often see in my practice is that parents are going there and they don't know what's happened. They don't know why, they don't know why the child or children have been taken away. And oftentimes they don't have any paperwork as to why this motion is being heard in court. And, that can seem like such a violation of due process. I can understand that 100%. The legislation allows them to do it. But also parents can push back by getting a lawyer and moving as expeditiously as quick as they can. I think, I hope that child protection law is going to be, for all of the reasons, Ms. Fletcher, that you alluded to. I hope the child protection law is going to take a forefront moving forward, and we pay more attention to that, because it is so oppressive, right? It is just by the very nature of the way it's set up. So it's a field that I know I'm dedicated to moving forward, and I know Ms. Strickland is dedicated to it moving forward. So the more information we can get out there about this process, the better. I wish we could give more specific advice, but for many reasons we can't, right? Because we don't want to advise on a case that we don't know everything about. Today is to give the general advice and answer the questions as generally as possible. But yeah, we can't stress enough. Contact a lawyer, contact legal aid, contact the Family Law Information Clinic. I know at LOSA does good work, especially with, providing alternative dispute resolutions, which could be, some kind of mediation or a healing circle or something that takes it out of the adversarial nature of court. And I know at LOSA is attuned to providing those kind of alternative dispute resolutions. Now, I don't want to inundate them with calls and speak for them, but I know they're out there and that it's very helpful. I do know that there are some young growing firms in London who are dedicated to child protection law. It's definitely an area that needs lots of work and lots of representation for the parents, because too often they are without resources, without representation, and child protection law moves so quickly, and time is of the essence because you have young children or a young child who are in care, could be in society's care for quite some time, and that there's some significant impacts on the case and your options if that's the scenario. So I cannot stress enough to those of you who may be in child protection court, or it looks like you may be heading that way, call a lawyer. They are your best advocate against a system where the resources are against you. So hopefully, at least if nothing else from my rant, you take that away, that, contact a lawyer, try to get legal advice as soon as possible, because that will be your best first step. Sorry for hijacking your
No, not at all. No,
presentation.
not at all. Okay. If anyone has any other questions, you can just unmute or put them in the chat, whatever is easiest.
Yep.
I just had a question, if I may. My name is Mike.
For sure.
The reason that the agency uses to take the children into care, is there a point in time that those reasons get substantiated, aside from just statements of they need to be in care? Does the agency need to justify its reason for that removal at any point in time in the court, aside from just, you know, saying a blank as a blanket? Basically what I'm asking, do you understand what I'm saying?
Yeah, no, I think I'm hearing you. So what will happen is if it gets to the point where they've removed and it's going to go to a court proceeding, when you get in front of a judge, the CAS will still have to provide their reasons as to why they've removed the child to the judge. But likely, again, if you haven't spoken to a lawyer and there's not much that you can say in court, and it's confusing. Often the judge is going to err on the side of caution and will make that temporary order. But in terms of substantiating their claim, they will need to do that to a judge. But if it gets to the point of removal, again, often judges are a little bit, they want to make sure that they're doing the right thing. They want to make sure they're being cautious. And so it's a little bit tricky. So again, speaking about the specifics of what's going on is really, really important to a lawyer, because they can go in and they can ask, figure out what the CAS has, figure out, you know, what's really going on at home, figure out who really needs to be spoken to, and kind of go from there.
Lastly, what can be accomplished at a settlement conference with the agency and the other parent involved in terms of getting access, putting a parenting plan together and getting the agency out of involvement?
Okay, yeah, that's a really good question. Again, it's going to depend on the specifics of the case and the different positions of all of the parties involved. But the purpose of a settlement conference is to bring the parties to the table, to figure out, you know, at the end of the day, what's in the best interest of the child, and to try and get some orders sort of nailed down that are going to do that. So in terms of, you know, specifics about like parenting time or access or things like that, it's going to be very dependent on the different positions that are present in the courtroom. And again, it's so important to just, I can't get into specific details because it's hard to not be able to, so I would just say having a conversation with a lawyer and laying out your position and laying out where things are so valuable to do, just because then they can give you, you know, what you should be looking for and asking for, and what steps to take in advance of the settlement conference and at the settlement conference. It's going to be so helpful, especially if you're thinking about parenting time or access or things like that.
Yeah, I thanks for that, Alex. I'll just add to that.
Yeah.
The most kind of confusing and I'll call it a dramatic, for lack of a better word, but the most confusing and dramatic part of a child protection proceeding is, you know, kind of those first 5 days, right? You know, removal from care. You know, as Alex said, there's no obligation to say where the kids are going, or the child. And so that is stressful in itself. And then the feeling that I am helpless, I don't have any agency here. Things were done and I don't know what to do. Then you may go to this motion and you don't even have the documents yet. And that seems wrong, and it is, but the legislation allows for it. One thing that you need to make sure of is, if you're in that position, contact duty counsel. Get the duty counsel number beforehand if you can, or call the courthouse and say, I need to speak to duty counsel. I have a motion date in child protection court on this and this time. And duty counsel, and I did duty counsel for child protection court, and almost all of the time, my direction to them, to the parents, were as follows. Yes, you don't have the material. That's not right. But today in court is only, the society CAS complying with the legislation. They have to bring it back into court within those 5 days. When you go there that day, the judge is not going to expect that you have mounted a defense, you've served and filed affidavits in response to each and every paragraph alleged against you. That's just not reasonable for the court to expect that of you. So when they have to make an order, though, the legislation says the court has to make an order, even if it's temporary and what we call without prejudice. And what that means is that without prejudice to your case, the court, when they make that order that day, say the child was placed with an aunt or something, the judge isn't saying on that day that I'm placing with the aunt and you've done something wrong, or you've done everything wrong that CAS has said. This is just a placeholder date so that you can get your lawyer and you can mount your defense to the fullest extent. And you can request that the society, CAS, argue their case in full with your full response. I don't know if they use this phrase anymore, but it used to be called a show cause hearing. And that makes sense in that CAS, you have to show cause for why you did what you did. And I believe, if you feel you're in a position to argue that motion as soon as possible to contest that CAS has done something wrong, you speak to a lawyer about that, because there is very specific evidence that needs to be argued to make sure that you have a good case to defend the CAS's motion to remove the children. And I think you can even get that kind of evidence or that kind of advice from the Family Law Information Clinic or from duty counsel. And they may say to you, in the small amount of time they have, they may say to you, I don't think you have it yet. Here are the things that you need to do. I often tell my clients, in CAS cases, you're the maker of your own evidence, because CAS cases are fluid. You can find out, you don't have to agree with them, and you should still get independent legal advice. But if CAS is saying, for example, I believe that you struggle with substance abuse. Okay, say that's their only concern. So then you can go to, I'm going to go to Addiction Services of Thames Valley, or I'm going to go to other addiction services. And I'm going to do a relapse prevention program. You complete it. Boom, you give them a certificate, and that concern, hopefully, is addressed. And now you bring your motion and you say, they were worried about my substance abuse or substance use, but here I am. I've taken a relapse prevention program. I've done this, I've done that. So you also have some agency once you find out what the concerns are. Now, I will say, there are times when the concerns are vague, right? Oh, well, we're just concerned, the place is dirty, and maybe it's not as specific as you want it to be. You have a right to find out really what the problem is. You need to know what case you face. And that goes in any type of law, not just child protection. But if they're saying that there's concerns, you hold their feet to the fire and you find out what those concerns are. They don't just get to vaguely tell you what the concerns are. You need evidence, because that's what cases are built on. All the more reason, again, why you should get some independent legal advice at the very least, to find out how to go about that. It will be, CAS cases are stressful. They're they beat you down, but I try to remind my clients that you have agency, and you can turn this around, or if you don't believe that their allegations are correct, we can dispute that. What I don't want my clients usually to have happen is get this us versus them kind of thinking about it. While I know, again, in the beginning, I said we're up against the state, parents are up against the state. You have to have a good working relationship with your worker, at least, even if it's a business relationship. You don't have to like them, you don't have to be best friends, but this is a worker that you're going to have to likely work with throughout the case. What I often, very often in my cases, what I get are, I need a new worker. And unfortunately, that rarely happens. And getting a court to order a different worker is very unlikely. And I've had so many cases kind of stall out because, you know, the two sides just won't come together. What I say to my clients is, you let the lawyers and you let, you know, the caseworkers that we have, you let us, you know, be your advocate, your staunch and vociferous advocate. You, on the other hand, don't give them any fodder to use against you, and that's what happens. So it's just like, you know, when somebody gets arrested and they say, you know, anything you say and do will be used against you in a court of law. That's the same thing, right? Don't say anything. I've thought for quite a while that it's kind of the same scenario, right? Something's happening to you, you have no control over it. Everybody's asking you all kinds of questions, and you don't know what you can or can't say. So be mindful of that. You have a right to get legal advice. You have a right to have this consent looked at. You have agency. And I think that's so important. Like, you just have to remind yourself, while I'm being told all of these bad things about myself and about my partner or whomever, you still have agency. You still have a right to a defense. You still have a right to put your best foot forward. And the story is not written, right? That's what I tell my clients all the time. The book is not written. That's the beautiful thing about CAS law and family law. You get to, if the ship is off course, you get to write it. And so that's why this law is so important. And I appreciate you guys coming out tonight. I think this is important stuff. And if you have any questions, by all means, keep asking them.
I think we've got a question in the chat. So I'm just going to read it first. So the question is, when the CAS gets to know about the child being mistreated or not safe, is there a warning or advisory meeting to be held, with the parents before a removal? And what is the general process? Remove, then investigate, or investigate, then remove if issues are proven? That's a great question. So a removal is not always going to be the first step. The CAS they will investigate, right? They're supposed to investigate. They have to have reasonable concern. They have to have, in order for a removal to happen, it has to be that they feel there's no other way to protect the child than removing the child from the home. And so they can investigate in advance. And I noted earlier on in the presentation that if someone is contacted, if you're contacted, your partner's contacted, someone else in the child's life is contacted, that should be sort of like a note to you to, again, get in contact with a lawyer, talk to them. Like Greg said, it's important to be cordial, respectful, and speak to the CAS, but it's also important to know that you have rights and you deserve to know what's going on and where things are at. And so it's important to have those conversations as soon as you're made aware of them with a lawyer and to obtain legal advice to know sort of where things are. It's hard to give you, again, unfortunately, a hard reading just because of specifics. But again, having those conversations as soon as you're made aware of them. And like I said, if there's an immediate concern, the CAS can do the removal, but they will have to, when they get in front of a judge, explain what their reasons behind that were. So I hope that answers your question. And if you have a follow-up, please feel free. Oh, there's a chat. Oh, okay, awesome.
Yeah, I will add to that,
Yeah.
Alex, and great answer. Most often, in my experience, but I will qualify that, most often, there's been warnings, right? Because the society's mandate is they have CAS's mandate, I keep saying society, but is to take the least intrusive option, right? When they intervene, they have to, the mandate is to take the least intrusive option. That's in the law. So if they have never spoken to you, right? Never given you any kind of warning that, you know, we've heard some concerns. And they remove the child from care over one incident. I don't know how bad it may be. You still need to speak to a lawyer. That's what we'll come back to, right? You still need to speak to a lawyer because the lawyer may say, yeah, they didn't give you any warning. They didn't even say, well, this is a problem. And that doesn't mean that that alone may, you know, dismiss the case or anything, because, you know, there are circumstances where one event may be so severe that the society has to do something. But more often than not, I will say, there is some kind of, they've reached out to you and they've asked you, we're concerned about this, will you work with us voluntarily? Okay. And I will say, I've had clients reach out to me even in that regard. If CAS is saying to you, I'd like to work with you voluntarily, it's okay to get independent legal advice off of that, right? Because, you know, it may be that their scope of whatever they want you to work with them is too far, too broad, too undefined. So that's fine too. You may have trouble with getting a lawyer who will come in at that stage, but it's worth looking into, because it's always good to know what your rights are, what the relevant issues are, right? Like if they're, you know, they want to talk to your grandma or something and your grandma never had any part of the case, well then, you know, a lawyer's going to say to you, why would they want to talk to your grandma? So again, coming back to getting independent legal advice, using these resources on the last page. I know it's kind of, it seems counterintuitive for us to give general legal information, then tell you to go talk to a lawyer. But again, you know, Alex has said our hands are tied in giving specific advice, of course. But I think a lawyer in these circumstances are your best defense in giving you resources and information that will level the playing field, so to speak. Thanks, Alex.
And just one other question. In January of 2019, I believe there was some new legislation from Ontario. Can you speak to that a bit? And regarding the privacy laws, that you're entitled to the workers' case notes, and I believe they have a time frame with that they're supposed to, if there's a request, formal request made in writing, of course, it has to be done that way, that they have response time.
Sure. So I believe, clarify if I'm wrong, but are you referring to Bill C-92? Is that the legislation you're referring to?
I
Oh,
don't
no.
recall exactly what it was called, but I know that it came out in January, I believe, of 2019.
Okay.
Yeah.
Okay.
Well, that was when, sorry, Alex.
No.
That was when the
Divorce Act.
CFSA was repealed, and then we got the CYFSA, the Child Youth and Family Services Act. And part of that, at least in my experience, part of the expansion was, and this was in conjunction with some case law, was, I think it was a step in the right direction. And what, there's a case out there that it was with, I can't remember, Kincardine, I think, their Children's Aid Society. But what it eventually said was, what it recognized was the power imbalance, and that we so often have a court and a society that looks at cases through a middle-class lens, and that is grossly prejudicial to many of the parents that we have in CAS court. It's so wrong to look at, like, for example, what I used to see a lot were cases built on the cleanliness of a home, right? And that would sometimes be the major factor, and you can think of how flawed that is, right? Maybe you don't have the resources to be able to clean your home every day. Maybe the worker caught you on 2 days out of 30 days in the month where your house was in disarray. It really tried to hammer down on giving parents more agency. Did it go far enough? I have my own opinions about that. But it did try to, I think, get a bit more equitable. We always need to be striving to more equity, and I don't think it's there yet. But I do think that the movement into the new regime, the CYFSA, I think was a harbinger for better things to come in that area. Hopefully that answered your question. I know I spoke generally, but it's the best I can do given the circumstances.
Yeah, and just the case notes, the worker case notes.
Oh, right, yes. So we all have parents have a right to the case notes, the workers' case notes. They have to be requested, while you do have an automatic right to them, because in family court, the distinction is that we have to, if the other party doesn't agree, we have to bring a motion to get these notes from the CAS. But if we're in CAS court, those notes are an automatic right, but they need to be requested. With respect to a timeline, are you talking about when they get it to us, or when we have to make the?
No, after the request, if they have a time frame that they have to be given to the parents.
They may have a timeline, but what I know is that is nominal. Like it's just, if it's there, it is not enforced with teeth, because child protection agencies are overworked. And that's not, and I'm not saying that that is an excuse that does away with that issue. But they're overworked, and the disclosure, we call it, disclosure of those notes are sometimes long coming. But what I do know is the best way to get it as soon as possible, if you're in court, is to serve CAS and serve the other party with a motion to get those notes, excuse me. Because that lights a fire under their butt. And frankly, that's what I've had to do when it's just taken too long, and perhaps the case is hinging on those notes, which it often does. I bring a motion, right? I'm like, this is getting ridiculous. We're on month 8 now, and I don't have these notes. So I'm going to bring a motion. And most often the motion alone will stir them to produce them, because they don't want to go before the court and say why they have delayed in it. Okay. But I've not, in my experience, had a CAS agency raked over the coals for missing some deadline in getting the information. What the court would likely usually be concerned about is if there was a motion pending, like, you've got to get this information to them because they're going to use it for the motion. Or if there's a settlement conference coming up, you've got to get this information to them so that the court can see the whole case, right? Or you're coming up to trial and we got to have this evidence. So I'd keep those things in mind. If there is a date coming up, a court date coming up that you need this information for, and they're still dragging, you know, I would be speaking to a lawyer about how can I bring a motion to compel them. Okay.
Thank you both.
Anybody else? These are great questions, by the way. You can probably stop sharing the screen.
Thank you very much.
Thank you. Thank you so much, everyone, for coming and asking great questions and and giving your time tonight. It's fantastic.
We will be doing more of these in the future, folks, not necessarily on this type of law, but have a look out for it. I know the Rights and Responsibilities Awareness Institute, they're always cranking out new presentations, so have a look out for that.
That would be great.